G'day, Nina. How are you?
Good, thanks, Andrew. How are you?
Ready for the big drive?
I don't know. It's your driving. I'm a bit scared.
2 days in the car together. Very frightening stuff. Particularly because I'm not allowed to use phones when we're driving. So
We're safety lawyers.
we're safety lawyers. We don't use phones. We're not quite on to managing pregnant worker yet, but but that's what the topic for the day is going to be. But I thought we'd just start off by saying the Liberal Party have signed up.
Yeah.
So the CFMEU administration will be appointed shortly.
They're going to pass the legislation now.
And let's just see what happens next. Not much is the answer, but anyway. Look, we've got a lot on today, so I thought we might flick into the flight attendant case.
Oh, yeah, the Virgin case.
Yeah. This is a funny case, isn't it?
It was
because there's a male flight attendant was sacked for drinking a glass of Prosecco 8 hours before a flight.
Yeah.
He wasn't sacked for another thing, which was relying on the fatigue.
So he said he couldn't make, I think, a 4 a.m. flight because he was too tired.
Yep.
But then went on a dating website and invited someone over for consensual relations. I don't know how they found out about that.
I don't know how they found out either, but the bottom line is I can't help feeling that was one of the major reasons. And he said, well, it helps me sleep.
Yeah. And the commission was like, no judgment. Literally, that's so funny.
But the funny part about this case is such a big organisation to have such a dishevelled practice around drinking.
Yeah, because it wasn't an established rule in their drug and alcohol policy.
No, they had several policies all around the place.
But it was loosely adhered to by staff.
So there you go. We put this on because it's a bit salacious and a bit of fun, but primarily to say drug and alcohol policies need to be ones which are consulted upon. They need to be singular, clear. They need to have warnings of termination as to what is, and they need a testing process that explains it. This had none of it.
And also, I sincerely doubt he would have met the intoxication threshold as well. So even I think if they'd had all that, I don't think it would not be considered harsh.
Yeah, look, who knows?
Like a glass of Prosecco.
But who knows? Who knows the truth? This is one of those cases where the facts seem fluid.
Yeah.
That making a Prosecco joke. Okay, I think it's probably time we moved on from that case.
That
was. Okay, we're going to go.
Another funny case.
Nina chose this case.
I did.
This is a Boilermaker case where a guy said he didn't grind onto a particular tank a penis shape.
Yeah.
When two people observed him doing it, when he made an admission of doing it at the first interview.
To the manager, yeah.
And then afterwards said, I never did. Now, I want to let you know the commissioner found he did.
Yeah.
But one of the interesting comments that I think about this case is the admission was not properly recorded as a contemporaneous note. And the commission put a bit of a dig in about, look, you're going to do an investigation. You're going to put facts to people. Make sure you've got a contemporaneous note. A contemporaneous note is a note taken at the time which you're having a conversation.
Or right after.
Or immediately aftermath, and an email that follows up is the same. But if you write it out, then you have evidence of what you've done, and it's very reliable evidence. It's reliable, and it's treated as evidence of the truth.
Yeah.
So it was just a fun case, but it did highlight this issue. Yes, the guy was terminated. It was a successful termination. There's no chance they had it because there was 2 witnesses who saw him doing it.
But they didn't have to jump through those hoops had they done the notes.
That's right.
It would have made things so much smoother.
I know. But there you go. So that's our Boilermaker case. What next do we got?
The dangers of a plea deal.
Yeah. Look, I'm not going to get caught up in this case, partly because it's one of the hardest cases to understand I've ever read. But commonly in safety law, when you're prosecuted, you'll enter into a negotiation. It's a sort of difficult dance you do with WorkSafe or Safe Work, or whoever you're doing it with, where you've been provided with the several folders of documents. There's an agreed statement of facts. It's not agreed, but it's what it's called at the front. And there is a series of complaints that are raised which have allegations in it. And many of those things you will not agree with. The biggest mistake you can do is agree to a plea deal where things are still left up in the air, or where to prove what you say you admit to requires the proof of things you don't admit to. And that's sort of what this case is about. They did a plea deal, and then when the prosecutor said, well, we need to put these other matters, they said, no, we've done a deal. That's the only thing that you can lead evidence upon. And they took that matter to the Court of Appeal, who looked perplexed and thought, what are these nongs doing in front of us? It's not a question of law. Why are you here? Nobody really knows why they were there, but the answer goes back to the heart of what I'm saying is when you come to do a plea deal, whether it's a criminal matter in a true sense or whether it's a quasi-criminal matter like safety law, spend a lot of time making sure that you followed causation through. If we admit to this, what else does the prosecution need to prove? Because it would be foolish to have an argument that just turns into a disputed fact hearing. So if you don't agree with things in a plea deal, what happens is you end up with a hearing which is like a trial called a disputed fact hearing. So the most important thing is setting out exactly what the deal is and the agreed statement of facts and the evidence that will be relied on by the prosecution. And they will do it if you do it carefully with them.
Mhm.
And then you don't end up spending hundreds of thousands of dollars arguing nuanced pieces of law to try and get around the problem you've created for yourself. So this case is a little bit on point, but it is a case that brings home to Nina and I our daily work about how precise you need to be when you are admitting something is wrong for a plea deal. Okay? So that's really the guts of the case.
To save you all from reading it.
Yeah, to save you all from reading both the trial or the plea part of it,
And
the
the
first
appeal.
instance and the appeal. Let's jump on to our next case. And by the way, Nina, I didn't see what time we started. When we tried this out to start with, you put your controlling hands on my throat and said,
about 6 minutes in.
we're 6 minutes in. We're
Yeah,
going well. Look at
yeah.
that. We're on our tiny screen again today because the big screen has died on us.
Yeah. So please bear with us if we
Okay.
can't see. All right. So this case was around employees having workarounds, particularly around safety. So with this one, it was Transport Canberra who run public buses in Canberra, and they need to do some maintenance on, I think they're called
Nipples
of the
grease
kingpins.
nipples.
Yeah, and so where it was located, they couldn't go under to basically grease them. So they came up with a solution where someone would be using the steering wheel.
That's right. They'd leave the bus on.
Yeah.
Turn the wheel so
Yeah.
they could get in behind
And
the
then
wheel.
someone would go and do it.
Yeah. Then a third guy walked past, and
And-
the guy was
Yeah.
driving. Said, "Oh, that must be him."
Yeah.
So he straightened the wheel and
And he-
squashed the guy underneath.
Yeah, so it's very, very serious injuries.
So, and this was a workaround, and there was a $1,000 method of fixing it.
Yeah, and
Like-
they got fined $375,000.
So just remember, again, this is my father's invitation: do not be too smart by heart.
Yeah, and
Look at what the easy solution is and do it. Don't do workarounds.
the crazy thing is, Andrew, they trained new employees in the workaround. It was an accepted practice. It wasn't like a one-time thing. So
Yeah. So
yeah,
working
don't do
underneath the bus when motors turned on and you're
No.
moving the wheels. I don't know how anyone could think that's a clever workaround. Anyway, it was, and it got them 300,000 plus. Okay. Well, let's jump on
Workers' comp claim.
workers' comp. This is a really fascinating case, and it's a case which affects all jurisdictions around hearing loss. Most people assume that if you suffer a hearing loss whilst you're employed with someone, the causative link is made, and therefore the last employer is the person who will be liable for the payment out for the permanent impairment of hearing. And what this case does is said, well, look, that sounds all right, but the truth is there must be some causative link between the nature of the noise that exists at the site that could cause the hearing loss. Geez, it's so simple, isn't it, when you think about it? But it's interesting because it's not often agitated as an issue, and it's very common, particularly in manufacturing, where it's just accepted. Now, as Nina raised when we're chatting about this, you normally don't feel you have much play in this because it's the insurer who's usually managing it. And what I'm trying to say to you is you do have play in it. If Nina suffered hearing loss working here, other than my screaming and shouting at people, other than that, there'd be, sorry, I don't think I do that much of that, but there's no way she could mount an argument that she suffered hearing loss in this workplace because there is no causative act. So when you're thinking about what are you going to do around risk, you run a manufacturing plant, but it's much more heavily automated than it was 10 years ago. Make sure that you do sound sampling on a regular basis so you can demonstrate no causative link, because it will be very common for 60, in this case was 74-year-old man, but very common for older people to suffer industrial loss over a long period of time, and it will progress, but it won't be your fault. It will be something that occurred in the past. So I think this is a really interesting case. Out of today, it's some of the more interesting law around remembering there is this connection between causation and hearing loss if you want to prove it. All right, I think we're on to our next case,
The
actually.
New Zealand one.
Yeah, look, I reckon this is just a fantastic case.
Yeah, you were very excited when you saw this.
Look,
one,
I'm interested in it. We've had now 2 cases of OHS practitioners being found liable for breach in Australia, but there's been a real reluctance to look at safety consultants. So safety managers where they seize an operational role, so they take responsibility for something, and then someone's injured. I think we had the racking incident last week maybe, where the safety person had done an assessment, said, look, the racking's not safe. They were engaged in advising people not to use the racking, but didn't do the job properly and didn't provide a safe method of avoiding that, and as a result of which they were charged. But in this case, this is an external consultant who's come into the business and said, God, you've got a terrible traffic management issue here.
You need to fix all this.
You need to urgently fix it. And
we'll do it for you.
Yeah, we'll do it. And then did nothing about it.
For 6 months.
Okay, you didn't know about this case. You've read it.
I summarised it for you.
But it's such a good case, isn't it? Because increasingly, as consultants take the place of employees, and we increasingly use them. We use them in return to work. We use them as safety. We use them in HR. We use them in a whole lot of places where they take a role of an employee in the business. New Zealand is the first place in Australia and New Zealand, both with model rules, all except Victoria, of course, because we haven't adopted them yet and will never do it for political reasons. But nonetheless, throughout Australia and New Zealand, this is the first case where a consultant has been held liable on their safety duty.
Yeah, because they were actively involved and did not.
And it's not a small fine. They end up with about a $60,000 fine, I think.
Yeah. But I think it's, just to be clear though, like contracting out to consultants doesn't mean you contract out that liability.
No, there was 300.
Because the other people also got done before.
Yeah, and they did end up with a 300,000?
I think so.
Yeah, I might be making that up, but I think it was a substantial fine.
Yeah, but it's interesting that it's expanded that liability so that consultants actually should be following through with any recommendations.
And look, can I, without having too big a punch at this, be aware there are consultants and there are consultants.
Yeah.
If you want to put a consultant on the site, there've got to be people who are going to be practical, care about your business, and don't give you off-the-shelf policies and processes and give you bits of advice without identifying true risk and proper controls, because that just exposes you. And if you engage them further, look, it may make them liable, but the bottom line here is there are not huge amounts of really good consultants who provide you what you want. So think carefully and make sure you choose the right person and you are satisfied exactly what their role is and responsibility, and you make sure they execute it.
Mm-hmm.
Because when they come on the site and they're doing stuff for you like an OHS manager would do, you're on liability,
yeah,
they're on liability, but they don't feel they're an employee. So they don't feel the same need for delivery, unless, of course, they're a good business and they feel delivery is everything. Anyway, I thought it's a really interesting case, and it is the first, so it's good we bring it.
On to the main topic.
Main topic.
All right.
We raised, this is an issue I've raised because we've now seen, I think over the last 6 to 12 months, so many cases of pregnant women being treated fairly poorly in workplaces. There is protections that sit in the National Employment Standards, which talk about providing people with alternative safe work, and if they can't take safe work, taking paid or unpaid leave, depending on what it is, what your agreements are that exist around it. But the most important part of what the National Employment Standards does is it recognises there's a need to protect pregnant women. Discrimination law protects it, a whole lot of things protect it. But what's critical to that is understanding the impact of the pregnancy upon the person and providing a safe place, not only for that person, but for the unborn child who is inside. So I want you to remember that frame of reference. Fair Work Act says must protect it, okay? Now, must protect it isn't hands off, just waiting for a complaint. So if you see somebody who's holding their back repeatedly, you've got to make the inquiries, because your obligations under Section 21, 22 in Victoria and like in other states says I've got to monitor health. I've got to satisfy it's a safe place of work. This isn't a duty where you wait for the pregnant woman to come to you.
No.
And I think, Nina, you have an even broader view as to the impact of pregnant workers, and it's not just the physical risks that sit with them.
Yeah, because I think we've seen a lot of cases around no safe job leave. So we all know that you have an obligation to provide a safe job. And oftentimes, if the pregnant woman is in a role where it's physically demanding, they are allocated other tasks, so say, such as in admin or whatever, because they can do it. And if they can't be allocated a safe job, then they get to go on no safe job leave. But we've always looked at it from the frame of physical hazards only. But I think with this day and age and the rise of psychological hazards, it's important to realize that that also could be the case. Like if they're in a role where they're being subjected to psychological hazards, then you also have an obligation to provide them with a safe place from those hazards as well.
And remember, pregnancy creates significant hormonal changes that exist and vulnerabilities in the woman who's pregnant. So there are real chances that particular behaviours where in a robust environment, which you could tolerate at
or like
one stage.
customer-facing roles, like where people are being screamed at or something. Yeah.
So look, I thought we'd raise that. Then let's have a look at Robinson's case.
You mean Tamara Hughes?
Oh, sorry. No,
Oh.
no, I've gone. Yes. So yes.
Yeah. Okay.
I've got the wrong case right in front of me. So just to know, I forgot to turn the page.
This is a recent case involving actually a law firm who I think does law, which is why it was shocking. And it was a paralegal who, the commissioner mentions this in the case. It involved a paralegal who was pregnant and told her law firm that she was going to take parental leave 6 weeks before she was due. I think she told them in November, and then in January they informed her of a pending redundancy, invited her to a consultation meeting where she was told she could have a support person, but they could not advocate on her behalf, and they could not be anyone who previously and currently worked for the firm. I don't know why they made those qualifications. Anyway, she attends the first consultation meeting, and immediately they say they're drafting a deed for her to resign instead of being made redundant, and they'll give her 3 weeks, because I think she was only entitled to 1 week's notice. And so they skipped the consultation altogether. Yeah. And then the next meeting, they provided her with the draft deed. She seemed amenable to it, said she'd go home and consider it. And they said, that's fine. Just tell everyone you're not coming back. And so she did. And then the next day, the director was like, where's your signed deed? And she said, please direct all your correspondence to my lawyer. And so nothing happened. And then a couple of days later, they decided to send her an email confirming that they'd had discussions that were without prejudice. She wanted to resign, and she did it off of her own accord. She was planning to sign the deed, and based on all that, she had resigned, and here's her final
That's
pay.
Exactly what you do after you've just been said, speak to my lawyer. You'd actually pour the petrol over yourself and just get...
Yeah. I don't know. It was a weird move, but basically, obviously, they objected
It didn't work either.
And the Fair Work Commission said, just basically annihilated them. It's clear power imbalance between the law firm and her. I think it was very clear. It was like almost scathing in the assessment, and basically said everything that they'd done was wrong. The fact that they hadn't consulted, gone straight into without prejudice discussions. So yeah, I think she would have. Oh wait, sorry. So that was just the first stage. So it was whether she could bring the general protections claim.
Yep.
The real fight is going to be next, and you best bet that she's going to win that case.
Yeah, they've just got to settle, haven't they?
Yeah.
After a jurisdictional decision like that, you just got to wonder. And look, again, the case doesn't highlight any great law, can I just say? And what it does highlight is, can you just, when you're about to make a decision, have a couple of thoughts. One, is it a wise thing to be terminating a pregnant employee? Is it opportunistic? Or is it genuine? Is there a proper reason? If this was genuine redundancy,
you can do it.
You can do it.
It's not. There's no prohibition on doing that.
So you're left, and that's I think what the commissioner was left implicitly saying. I don't know why you were doing this. I can't think of a good reason you were doing this, except the opportunity arose.
And it's a reverse onus of proof, right?
Yeah.
So you've got to have got that objective reasoning and evidence of it as well.
Yeah. So look, I want to put it out there because it was our topic for today, and it is a case which just reflects the very type of issues that pregnant women face.
Mm.
It's usually on the other end when they want to come back for a leave and they want to work 2 days a week and people go, oh, there's no business, we can't do that. And then there is the reasonable business argument that sits on the other side of it. That's where we see most of the cases. But I just want people to remember, humanity's grown up by people having children. Businesses have historically adjusted around that. Centuries have adjusted around that. Don't be opportunistic. Don't think this is an easy take, because it's terrible for the person. Absolutely shocking. But what it does to you culturally is just devastating.
And reputationally, like this firm now is going to, people associate that with how you treat your pregnant staff.
Yeah. All right. Well, why don't we get on to the case study? Nina, can you read this on our small screen, or do you need to go?
I can. Brioni was a sales assistant at Tough Tom's Hardware, TTH.
Named after Tom.
Yeah. She was 4 months pregnant. Her back had started to ache, and she still felt incessantly nauseous. Certain smells really set it off, including some of the fertilizers, paints, and solvents, and the sausage stall. What? I stole it from Bunnings. Her doctor had warned that she needed to be careful when lifting over 5 kilos and not to twist or bend too much. She had developed gestational diabetes, suddenly gaining weight, and was struggling psychologically. Her boss, Tony, had said a few times, "It's going to be a big baby." Each time it hurt her because she knew her little baby was quite small, but the diabetes had caused significant weight gain. She felt she looked fat and horrible. One day, he put his palm on her tummy and said, "I think he's going to be a ruck man," smiled paternally, and walked away. An ultrasound that morning had said her baby was a girl. She approached Bev in HR and said she was uncomfortable with Tony's comments and wanted his comments and touching to stop. She gave her a medical certificate that set out her limits at work. Bev told her to tell the boys what they could and couldn't do. It would be fine. She said she would talk with Tony. As in Bev would talk with Tony?
Bev.
2 weeks later, Bev approached. She explained there'd been a downturn in business and Brioni's role was redundant. There was no work they could safely give her.
All right.
There was no work they could safely give her.
Yeah, they couldn't give her any
work. As in she couldn't be redeployed.
Yeah. Okay. Oh, sorry, I didn't put the right legal language.
I'm just making it sure so no one's confused.
Everyone understands, yeah. 2 days in a car. We're already not getting on. Does Brioni have a general protections and discrimination claim?
Yes.
Just about everything about it. Some of those things some people may think are, innocuous. They're nothing. But touching someone's tummy when they're pregnant without their consent, it's not flash. Okay.
No.
Making comments about the child, making comments about her.
Yeah. She's also raised her complaints and also provided medical evidence of what she feels comfortable with boundaries wise.
So the answer is yes, and certainly the termination is going to be almost impossible to prove because none of it was put through any proper consultation process. So none of the evidence was put in front of her. And although general protections doesn't require procedural fairness, the absence of it at the time of termination goes to the reverse onus. So you're going to have to manufacture something after the event. It's not going to look flash. Has there been any breach of Fair Work Act, and what is it?
Yeah, they haven't provided her. Well, they haven't really considered safe job at all.
No, it's their obligation. So their obligation is to work out what is a safe job and actually put a plan in place. So there's a breach there. It's not good, is it? I know this all seemed pretty low level, but it's not flash at all.
No.
Is there an unfair dismissal? Absolutely. Failure of consultation. Okay. So at the moment, she's winning every battle, isn't she?
Yeah, definitely unfair process.
Yeah. And then did anyone breach any safety law?
Yeah.
Yeah. And this has sort of got psychological hazards sort of written on it.
I don't think it'd be reckless endangerment or anything. It'd just be
it's primary
breaches.
Primary breach. And look, the problem is that for Tom, the boss, Tony, the boss,
Tony, unintentional doesn't matter. I think the fact that he's aware now that how
he's a Section 27 WHS or 144 Victorian. He's got an officer's breach as well.
Yeah, and actually, this also could veer into all this sex-based discrimination stuff too, because he's touching her without knowing if she's going to accept it. No, because I know we focus about we focus about the pregnancy aspect, but do you know what I mean? People always think it's got to be intentional, but with the new changes on the Fair Work Act, it's everything could be really. Yeah.
So look, I want to put it out there because
what's the penalty?
What's the penalty? Penalty is not going to be a high penalty, I've got to tell you. It's sort of 80s to 100,000 in sort of financial penalties because it's primary duty breaches.
Yeah, but I think they've got a much stronger general protections claim.
Yeah, general protections claim is a good claim.
Mm.
So there you go. Now look, I think we've done pretty well with the small computer for the second week. We can hardly see anything on this computer.
It's like this big.
Except for my cone
From a
head. We can see
distance,
my
yeah.
cone head.
Yeah.
And we'll be travelling for the next 2 days, so we won't see it. But congratulations.
Give
You
us
the
a thumbs up.
and doing so well on such a tough day. Bye-bye, everyone.
See ya.